I call the Honourable Dr. Wayne Mapp.
He couldn't even get into the law school or the polytech. commercial law. Assistant lecturer commercial law.
Mr. Speaker, can I say if the opposition wishes to interject, they could at least get their facts right for a change. And I guess, doesn't that tell you everything? Doesn't that actually tell you everything? Right from the get-go, Mr. Mallard, amongst others, are consistent that they simply cannot get the facts correct. There are other ways of describing that, of course, but to do so would almost be certainly unparliamentary. It is extraordinary, Mr. Speaker, when I listen, and I've been listening throughout the morning, both in my office and here, the nature of the speeches. And I want to pick up on a particular point made by Mr. Robinson in particular. He says that the law is certain. Well, it is true that there is a Supreme Court decision, and to the extent that Supreme Court decisions are final, I guess in that sense it is certain. But the Supreme Court itself identified the core problem, because this is what they actually said in paragraph 15 of the decision. In the film industry, services of the relevant kind were virtually always provided pursuant to a contract for services. What does that mean? That means the normal pattern is to be an independent contractor. That is the problem with the 3'6" decision. The court knew that was the normal pattern, but then they had to take cognizance of the Employment Relations Act 2000, in particular Section 6, subsection 3. And this is what that section says. The court or the authority must consider all relevant matters, including any matters that indicate intention purposes, and not to consider as determining statements that describe the situation, Section 6(3), subsection B, subpara B. So the problem is this. The legislation itself leads to uncertainty. And that is why in each of the cases that were heard, the Employment Relations Authority, the Employment Court, the Court of Appeal, and ultimately the Supreme Court, each and every part of that level came to a different decision. The legislation itself leads to that outcome. The contrast with the legislation that we're putting up is that there is certainty. The certainty will be given by simply having reference to the written contract. And the written contract will determine absolutely the outcome. If it says in writing an employment agreement, that's what it'll be. If it says in writing an independent contract agreement, that's what it will be. Hard to be clearer than that. A completely different approach to Labor's understanding of the ARA subsection 6(3), which is essentially a subjective test. Not objective. An objective test would be, say, what was the party's intention expressed in writing? Couldn't be clearer than that. And that is why this legislation is necessary. Now, I've been listening and saying there hadn't been problems in Avatar and so on and so forth. And of course, in a sense, that's true. But there was something that changed, however, and that was the destruction of trust. And my colleague, the Honourable Tauhenari, referred to that specific point. The opposition can say it's all irrelevant, the boycott was withdrawn, many films have been made since 3'6", but the world changed when the nuclear option was used. And I use those words because Sir Peter Jackson used them. And he said, in fact, it was made even before any communication with them. That destroyed trust. And that trust hadn't been restored simply by withdrawing the boycott. That didn't change the issue of trust. In fact, what it indicated is that who would know that down the track, halfway through the production, near the end of the production, that someone wouldn't just pull us straight, notwithstanding what they'd said before. And that is the problem when you destroy trust. You remove the fundamentals of reliability and certainty from the industry. So part of the package here is that producing certainty in the law became an imperative, a necessity to ensure that the work could be done in New Zealand so that everyone involved knew the score, whether they were an employee or a contractor. Mr. Speaker, Mr.
The
Chairman.
Honourable Dr. Wayne Mapp.
Mr. Chairman, can I say this? There's a very clear choice here, a very clear choice. Are you willing to take the practical and pragmatic and necessary steps to ensure the survival of the big budget film industry in New Zealand or not? Now, we are clear on that. We are prepared to take those practical steps. Not enough to just go out and say we support the film industry, but are you prepared to take the practical measures that will ensure that outcome? When that test came to this government, we made sure that the outcome was clear. And there are thousands of people, especially in this city, whose livelihoods are dependent on that pragmatic, practical decision being taken. The other side, I guess partly from the luxury of opposition, to be fair, largely because they are heavily influenced by their relationship with the unions and their personal relationship with members of the unions, have taken the luxury that say, well, we don't have to be practical, we'll just retreat to an ideological position. But I would ask that party, if the situation had been reversed, would they have actually taken the practical step? Or would they have let ideology get in the way and see a $2.8 billion industry down the drain? Well, we were not prepared to see that, take that risk, and we've taken the measures. They have let ideologically driven point of view blind them to the reality that faced this country over the last 4 weeks.
Members, we